Good morning. Thank you very much. I also would like to start by thanking Lori, Congressman Fattah, and Owen for their incredible support at different levels. Owen referred to I'm the director of the G to I project. He described it as non-trivial, which I consider to be the greatest compliment, better than most of my writing gets from my dean. So my interest is the question that both Jeff and BJ raised, which is how do you reason from scientific research to the individual decision-making that courts are interested in? And basically, this is the intersection question, the intersection between science and the law. Back in 1999, I tried to describe it somewhat poetically as saying that while science attempts to discover the universals hiding among the particulars, trial courts attempt to discover the particulars hiding among the universals. And the basic insight there is that scientists study group behavior or populations, and the law, of course, is interested in that particular adolescent, that particular alleged psychopath, that particular person who might be described as a sexually violent predator. And how do you reason from that group data to the individual? What the MacArthur Project is supporting is a committee. We have about 13 international scholars from Cambridge University all the way to California in areas of statistics, behavioral psychology, neuroscience, and basically the objective is to figure out the best ways to draw inferences from group data to individual cases, both statistically and in terms of scientific research and methods, but also, and perhaps most importantly, how do you translate it? How do you convey that information to jurors and judges, the decision makers in these areas? We call this G to I because if you're working with scientists, you need something clever like this. And we've actually worked many months on moving from the capital G to the little I. And just recently, Mark Reichel sent me an email suggesting to subscript the to. So if anybody has suggestions, we welcome it on the G to I. This, of course, is a phenomenon that's been noticed for some time. Back in the 1980s, John Monahan and Larry Walker wrote an article on what they call social frameworks, what we call empirical frameworks. And that's the first question is the general question, the framework question, and that is, does the phenomenon even exist? And that's what scientists are trying to answer. So what BJ was talking about and many others have researched, the question of whether kids are different. Are there adolescent developmental differences, and how do they manifest themselves? What do they look like? As Jeff pointed out earlier, this is a phenomenon and an issue that's not unique to neuroscience. It's presented everywhere, so the question of whether repressed memories exists or does not exist as a phenomenon, psychopathy, but it's also true in toxic tort cases. Is bendectin a teratogen? Does bendectin cause birth defects, which of course was the scientific question presented in the Daubert versus Merrill Dow Pharmaceuticals case. And then, of course, the law is interested first in the medical context they call general causation, but then they're also interested in what in the medical context they call specific causation, or the diagnostic component. Is this case an instance of the general phenomenon? Is this case an instance of the general phenomenon? So we ask the question whether this particular defendant adolescent is or is not developmentally mature, which BJ alluded to. Was the plaintiff's memory repressed in this particular case? Is the defendant a psychopath, which was Kent Keel's testimony in the Dugan case, and were the plaintiff's birth defects caused by bendectin? Again, as Jeff pointed out, this G to I issue is pervasive in the use of scientific research. In fact, I would argue that there's no area of applied science that does not present the G to I issue. If you think that the G to I issue is not presented, it's probably involving an area of not very good science. So a lot of forensic identification scientists come in and they will testify that this particular cartridge case came from this particular bullet or this particular gun to the exclusion of all other guns in the world. And they are not really testifying to or giving you the general probabilistic information or the specific probabilities that are associated with the diagnostic judgment that's being offered. But it comes up a lot in medical causation, toxic tort cases. So for example, if you have a plaintiff that has leukemia and you're claiming that the plaintiff's leukemia came from being exposed, say, to benzene, which the defendant was responsible for, the question is whether the plaintiff's leukemia came from the exposure to benzene that the defendant was responsible for. In the world, there is benzene out there, and benzene has a very high association with causing leukemia. In fact, what epidemiologists call the relative risk is around 20. So it means that you have a 20 times increased risk of getting leukemia if you're exposed to benzene than the base rate information background. But of course, not everybody with leukemia got it from benzene. In fact, it's a very small percentage of all leukemia cases that are caused by benzene. So other things cause leukemia. Tobacco smoke causes leukemia, also at around a 20 relative risk. Radiation has a very high relative risk, but causes a relatively small number of leukemia cases. Formaldehyde causes leukemia. Electromagnetic fields are accused or alleged to cause leukemia, but a very low relative risk. But one of the problems for the law is that most of the causes for leukemia are unknown. They're idiopathic. In fact, 80% of cases are supposed to be idiopathic. And so when you have an individual plaintiff, the question is statistically, when you're making that inference from general causation data, so even if you know that there's a relative risk, and even if you know that benzene can cause leukemia, the question in this case is whether benzene did cause this particular plaintiff's leukemia. Well, the same judgments are going on in adolescent brain development. And so the question is raised, when does group-based data tell us something meaningful about an individual adolescent? How do courts handle G to I, which is something we're looking at? And we're also asking the question, how should courts handle G to I? I didn't see BJ's screen because I was too far on the side, but I suspect it looks something like this. And that is, if you're measuring developmental maturity, you may have two groups that you're comparing, 15 and 16-year-olds to 23 and 24-year-olds. And you might find that on whatever task they're given, they have a certain distribution, will likely be a normal distribution of developmental maturity. Some kids are more mature than other kids. And then if you compare that to what the law considers to be adults, 23 and 24-year-olds, you get a different distribution. So on average, adults are better. They are more developmentally mature than the adolescents. But as you can see from these overlapping bell-shaped curves, there's a lot of overlap. There are many adolescents that are much better than adults, and there are many adults that are worse than a lot of adolescents. And so the question for the lawyer is, well, where does my client show up here? Is there a diagnostic test that will tell us, is your client here, which is right in the middle of the adolescent group, here in these overlapping groups, or what the law might consider to be clearly developmentally mature? And right now, we don't have those diagnostic tests. And so the question is, well, how should you handle then these general data, when you have decision makers that have to make decisions about individual cases? So it may be, and this is just a problem at the intersection of science and the law, it may be that the scientists don't have an answer to an empirical question, but the law nonetheless asks the empirical question and expects some expert to come along and give us an answer. And for $750 an hour, you almost invariably will find some expert somewhere to provide that answer. So in studying this question, one of the things we look at are the legal standards of admissibility. Virtually, as I said, virtually all applied science that's relevant in legal disputes comes from general principles and has the potential, at least, both scientifically and legally, to be applied diagnostically or in individual cases. I would emphasize that the rules of admissibility apply both at the general level, and that's the way courts do it in medical causation cases. That is, the rules of admissibility apply to general causation and to specific causation. Some examples of eyewitness identification. You have the general phenomenon, say, of cross-racial identifications being less accurate than same-race identifications, and then the question of whether this particular witness was accurate or not. In medical causation, you have the general causation question of benzene causing leukemia, and you have the specific causation question of whether benzene caused the plaintiff's leukemia. I'm going to go through very quickly just to emphasize that the rules that apply, I don't want to spend very much time on it, of course, are Daubert, and Daubert is 3 cases. It's a Daubert trilogy. Daubert, General Electric versus Joyner. In General Electric versus Joyner, the court held that the standard of review on appeal is an abuse of discretion standard. And of course, in Kumho Tire, the court held that the rules of evidence, the gatekeeping function, applies to all expert testimony. Rule 702, interestingly, and judges point this out all the time, people like to talk about Daubert, but remember that Rule 702 is actually amended after the Daubert trilogy was decided, so we really should talk more about Rule 702, and those are the provisions of it. And then, of course, Illinois is a Frye state, and still, it's not a majority anymore. There's now a majority of Daubert states, but even some classically Frye states, like California now, there's a November decision in California called Sargon that used the Daubert framework for deciding a expert testimony issue. So the question of judicial practice. What are the courts doing today? There is no general theory. Not surprisingly, courts haven't really given much deep thought to the question of G to I, much less the question of when an expert should be allowed to testify to the I of G, the individual application or diagnostics. Eyewitness identification is an area where eyewitness identification, interestingly, the courts basically say you can testify to the general framework. You can testify that accuracy judgments are lower for cross-racial identifications or gun focus or other things, but you cannot testify, except in a few jurisdictions, to the diagnostic judgment of whether a particular witness was accurate or not. The only real exception to that is Texas, where the Texas Court of Criminal Appeals, shockingly, has said you have to testify to the I of G to I. They didn't put it in that way. I'm actually giving a presentation for the Texas Court of Criminal Appeals, and that will be my lead slide to try to figure out what they're doing. In medical causation, however, the courts say if you don't testify to the I, you are excluded. You are excluded on summary judgment. So you have this odd juxtaposition where in medical causation, you are, in most cases, being limited to the general, but in medical causation, you are obligated to testify to both the general and the specific. And the question is, well, why? DNA is interesting. DNA experts, the best scientists in the forensic identification field, actually only testify to the general. They provide random match probabilities, which are population-based, whereas the really bad forensic identification scientists, the handwriting identification people, the bite mark people, they testify to the I. They testify to the specific, the diagnostic. Gender stereotyping and implicit bias, courts are actually all over the place, sometimes requiring you stay at the G and other times requiring you to go to the I. Basically what courts are doing are following the practitioners in the field. If the practitioners, like handwriting experts, say, yes, I can testify to diagnostic information and specific, the courts will let them do that. And if you have a good scientist that comes in, like a DNA expert, and they say, we really can't say in the individual case, then the courts follow the scientist's lead. That's consistent with Frye, to be deferential to the field. It's inconsistent with Daubert, because Daubert requires judges to have some independent judgment about this. So one of the things we're doing is looking at how courts are actually dealing with this issue. I see that I don't have a lot of time, so I'll go through this pretty quickly. We're coming up with anatomies to see how courts themselves deal with these questions. I'm going to jump. We started with a generic view of it, looking at the legal relevance, but what I really want to do is talk about the Graham versus Florida case that Chris mentioned, In Graham, of course, the court raised the issue of neuroscience. The constitutional question under the Eighth Amendment is, does the Eighth Amendment prohibit a sentence of life without parole for an adolescent convicted of a non-homicide offense? The problem there is to operationalize that Eighth Amendment mandate. You have to operationalize it as a legal matter, and you also have to operationalize it as a scientific matter. As a legal matter, the question is, are kids different? As a scientific matter, as Larry Steinberg's work and others, BJ's work indicates, you have to operationalize it so you can test it, so you can actually measure it, which might involve peer pressure and other things in the laboratory area. And then you also have to legally operationalize the question of where do you stop the legal judgment? So in the Graham case and in Roper, there's a debate between Justices Kennedy and Scalia on whether these should be done on a case-by-case basis or they should be done as a group basis. And the court basically came to the conclusion, as provided here, that it is difficult even for expert psychologists to differentiate between the juvenile offender whose crime reflects unfortunate yet transient immaturity and the rare juvenile offender whose crime reflects irreparable corruption. That's the G to I issue. Unfortunately, we didn't have it published so that Justice Kennedy was citing us for that proposition. But basically what Justice Kennedy was saying is we have to treat this as a group because we cannot distinguish and do diagnostics on individuals. But of course, and I'll leave you here, the problem is that you have to go back and you have to sentence Terrence Graham. And so before the trial court has Terrence Graham. Life without parole is not permitted anymore. And here I set up this juxtaposition of the prosecution's expert versus defense expert, and Terrence got 25 years. Whether the science supported that or not, as was indicated here, scientists testified on the I of G to I, notwithstanding Justice Kennedy's specific statement saying we can't actually do that. But the law has to do it anyway. With that, I thank you very much, and I look forward to your questions.